Assalamualaikum warahmatullahi wabarakatuh. We are from group number 2 and today we will be presenting to you guys about adjudication. Our group consists of Muhammad Farooq Nashran, Nur Awatif, Muhammad Iqmal Hafizi, Nur Balkis, Muhammad Uzair and Intan Nur Shafiqah.
Assalamualaikum and hello. My name is Muhammad Farooq Nashran bin Muhammad Iskandar, and I will be joining you guys today to talk about adjudication. Adjudication is one of the dispute resolution method related to construction industry often used in Malaysia. Different from its counterpart, arbitration and mediation, adjudication is only a temporary binding. It is a fast and cost-effective way to resolve disputes in construction projects such as payment delays, contract breaches, or project variations. Now, let me introduce you guys to the parties that is usually involved in adjudication. The first one is referring party. This is the party that initiates the adjudication by raising a dispute. For example, a contractor claiming unpaid money from the employer. The second one is responding party. This is the party against whom the dispute is raised. For example, an employer or client who dispute the contractor's claim. Finally, we have the adjudicator. An adjudicator is an independent third-party expert who reviews the case and makes a decision based on the facts given by both parties. The adjudicator is often a construction industry expert or legal professional.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Awati binti Muhammad Kamal Rizwan. Next, I will present about what, why, when, where, and how the adjudication is worked. What is adjudication? Adjudication is an alternative dispute resolution or ADR process where an independent adjudicator is appointed to resolve dispute. It under the Construction Industry Payment and Adjudication Act 2012 (CIPA) in Malaysia, and this process is specifically used to address payment dispute in the construction sector. The adjudicator will review the evidence and issue a binding decision that both parties must be complied with immediately. If both parties disagree with the decision, they can issue it through the arbitration or court litigation. Next is why use adjudication. First and foremost, adjudication is speedy resolution, where an adjudicator is generally give their decision within 45 days, so the party will get a quick resolution, unlike court case that can take months or years. Secondly, is it because it cost effectiveness, where the both party involved can avoid the high expenses of going to court or arbitration. It's because it the streamlined process and quicker decision we save money for both parties that involved. Lastly is because flexibility and simplicity. The adjudication process is less formal than court procedure, it allowing for a more flexible and straightforward approach to resolve the dispute. When use adjudication. Adjudication can be used at any time during a project construction or after its completion. It used to resolve a payment dispute quickly when a party like a contractor or supplier has been not paid on time. They can initiate adjudication to claim the overdue payment. Number two is to avoid court litigation. When a party is prefer an expedited resolution instead of long and costly legal proceeding. Next is where can use adjudication. Adjudication is applicable to both public and private sector projects, and it applies to the payment dispute for all construction work contract, consultancy service contract, and supply of related material or equipment within Malaysia. Adjudication is cover dispute related to the construction, installation, alteration, or demolition of any building, erection, structure, fence, whether it's construct wholly or partly. And like building like road, railway, drainage, dam, earthwork, or reclamation works. And now we will move to how adjudication works under the Construction Industry Payment and Adjudication Act (CIPA). Step number 1, the process begins when the unpaid party, that referred as Party A, serve a payment claim to the non-paying party, which is Party B, and this claim will outline the amount due and why it's being claimed. And step number 2, the Party B has a 10-day to respond by serving a payment response to Party A. This response may include a reason for not paying or confirming part of the claim. Step number 3, if the dispute is not resolved, the Party A will appoint adjudicator and serve a notice of adjudication to Party B, and this step must be done within 10 days. And step number 4, alternatively, the both parties can request the AIAC or Asian International Arbitration Centre to appoint an adjudicator, and this must be complete within 5 days. Step number 5, once the adjudicator is appointed, Party A serve an adjudication claim to Party B, and this must be done within 10 days, detailing their argument and evidence. Step number 6, Party B has a 10-day to serve an adjudication response to Party A, and this document include their defense or counter-argument. Step number 6, following this, Party A may serve an adjudication reply within 5 days to address any point raised in Party B's response. Step number 8, finally, the adjudicator will review the submission from both parties and issue a decision within 45 days, and this decision is binding and provide a resolution to the dispute.
Assalamualaikum. My name is Iqmal, and now I would like to present about advantages of adjudication compared to arbitration and mediation. For the first advantages is binding decision. For adjudication, results in a binding decision that parties must comply with providing legal certainty. Compared to arbitration, it also results in a binding decision, but with limited grounds for appeal. For the mediation, it's not binding unless a formal agreement is reached, which may leave many issues. For the second advantage is interim solution. For adjudication, it can provide interim relief, addressing urgent issue during the process. Compared to arbitration, it may also provide interim measures, but it can be more complex. For the mediation, it generally does not offer interim relief. For the last advantages is expert decision makers. For adjudication, it often involves experts in the relevant field, leading to informed decisions. Compared to arbitration, parties can choose arbitrators with specific expertise. For the mediation, mediators may not have decision-making authority, and their expertise may vary. Next, this is disadvantages of adjudication compared to arbitration and mediation. For the first disadvantages is less flexibility. For adjudication, the procedure can be more rigid with less room for negotiation compared to mediation. For the arbitration, the offers flexibility in terms of process and rules, as parties can agree on how to proceed. For the mediation, it was highly flexible, allowing parties to craft their own solution. For the next disadvantages is limited scope for review. For the adjudication, the decisions may have limited grounds for appeal, which can be problematic if a party feels the decision is unjust. Compared to arbitration, it also has limited appeal options, but the process can be more flexible. For the mediation, since decisions are not binding, parties can revisit issues or seek other resolutions. And for the last disadvantages is enforcement issues. For the adjudication, While binding, enforcement can be challenging depending on jurisdiction. Compared to arbitration, it was generally has strong enforcement mechanism due to international treaties. And last is mediation. It was requires formalization of agreements for enforcement, which may not always happen. For the overall, the choice among these methods depends on the specific need and circumstance of the parties involved.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nurbalkis binti Aziz, and today I will cover on identify of Act and Statutes of Adjudication. Before we proceed, let's understanding what an Act and a Statute are. Acts is a primary legislation by a legislative body such as Parliament, while statute is any written law or legislation enacted by the government. The primary act and statute in adjudication is Construction Industry Payment and Adjudication Act 2012 or CIPA 2012. The main objective of CIPA is to provide a faster and efficient of settling payment disputes in the construction industry. So, here are some important features in CIPA. The first one, right to interim payments. Under CIPA, parties involved in the construction contract, for example in construction, extension, maintenance in any building, road, drainage, mechanical or electrical works, have the right to claim the interim payments. The second one, adjudication process. If a payment dispute arises, the Act provides a clear adjudication process. An independent adjudicator is appointed either by mutual agreement or through the AIAC, Asian International Arbitration Center, to resolve the matter swiftly. The third one, adjudicator decision. The adjudicator decision is legally binding. If one party fails to comply, the decision can be enforced in court, giving the winning party legal backing the claim payment. And the last one, suspension of work. In cases where payment is not made as decided by the adjudicator, the unpaid party has the legal right to suspend or reduce their scope of work. Now let's take a look example of statute used in adjudication. For Section 5, Payment Claim. This section allows any party who has not been paid to file a claim for payment. It sets the stage for the adjudication process, ensuring that dispute can be formally addressed. The next one in Section 28, Enforcement of the adjudicator decision as a court judgment. This section empowers the winning party to enforce the adjudicator decision as though it were a high court judgment. This gives a strong legal weight, ensuring compliance. And the last one, suspension in Section 29, suspension or reduction of work due to unpaid amounts. If a party faces unpaid claims, they have the right to suspend or reduce their work under this section, and they should give written notice of intention within 14 days. Now, let's look at the PAM adjudication rules, which are outlined in Clause 36. These rules serve as a guide for resolving dispute in the Malaysian construction industry. Clause 36.1 Condition Precedent. Under this clause, adjudication is a mandatory step before dispute can proceed to arbitration. This means that dispute arising during the project must first be referred to adjudication as an initial dispute resolution mechanism. However, if the project has already achieved practical completion, the dispute resolution process shifts to Clause 37, which is arbitration. Essentially, adjudication under Clause 36 apply on ongoing projects, which is to ensure swift and efficient resolution of disputes without delaying. Clause 36.2 Notice for adjudication. A written notice must be issued by the party referring the dispute of adjudication. If the parties cannot agree on adjudicator within 21 days, PAM will appoint one of adjudicator. This to ensure disputes for ongoing projects are addressed promptly and do not remain unresolved for extended periods. Clause 36.3 Adjudication Process. The appointed adjudicator must follow the PAM adjudication rules or other applicable rules. The process is structured. to resolve disputes quickly, minimize interruption to the ongoing project, and it also to ensure the fairness and efficiency while maintaining progress on the site. And the last one, under clause 36.4, which is decision of adjudication. The decision of adjudication is both final and binding for the parties involved. However, if either party dissatisfied with the decision, they may escalate the dispute to the arbitration under clause 37, and it is done within 6 weeks of the adjudication decision. Now, let's look on comparison of CPAR, AIAC, PAM, and CIDB if you are still do not understand. So, the main function for CPAR, which is to establish legal framework to resolve payment disputes in the construction industry. Function of AIAC, provide alternative dispute resolution ADR services, including adjudication, arbitration, and mediation. Function of PAN is to provide standard construction contracts, and CIDB regulates and develops the construction industry in Malaysia. And now, role in adjudication in CIPA, which is create the legal framework for adjudication, and AIAC is primary administrator of adjudication under CIPA 2012. Role PAM, which is to provide adjudication mechanism in the standard contract, while CIDB not directly involved but to ensure industry standard compliance. And now, let's look at related legislation under CIPA, which is CIPA 2012, and AISC, which is administered under CIPA, and ADR principle. Related regulation for PAM not tied to any specific act, while CIDB depends on Act 520, which is Construction Industry Development Board Act 1994. And the features in CIPA, which is the established right interim payments, ensure quick resolution of payment dispute within 45 days. And features for AIAC, which is appoint adjudicators, provide guidelines and code of ethics of adjudicators, and arbitration and mediation service. While features for PAM, which is define responsibility between employer, contractor, and architect. And the last one, features for CIDB, which is registers contractors and construction workers, enforce codes and practice and industry standard, and also provide professional training.
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Uzair bin Harizal and I will be presenting to you guys about the proposed solutions for our chosen alternative dispute resolution, which is adjudication. For the proposed solution from the selected alternative dispute resolutions are: first, the judgment or verdict by the adjudicator. Judgment or verdict is a legal decision which is made by determining who is correct or incorrect, and it is determined by the evidence and law. Next, the second proposed solution for the selected ADR are by damage or compensation. It is provided if one party has endured harm, so the adjudicator can mandate that monetary compensation to be granted to the damaged party by the party at fault. And lastly, the proposed solution for the selected ADR are injunction, or also known as order. The adjudicator could issue a command to carry out or stop from doing something. As for the example, the adjudicator can issue an order to prohibit certain action or demanding a party to perform a specific step.
Example of case: Anas Construction versus JKP. Background: Anas Construction, the appellant, was appointed as the main contractor by JKP, the respondent, for a project under a construction contract dated 9 April 2015. A dispute arose over the respondent's failure to pay 855,074 ringgit and 21 cents in professional fees incurred for safety and crack reports. Adjudication claim: The appellant initiated adjudication proceeding under CIPA, relying on clauses 28, 55, and 56 of the contract to support their payment claim. The respondent disputed the claim, asserting that professional fees did not fall under the contract scope as per CIPA and reference clause 36.5 instead. Adjudicator decision. The adjudicator decided in favor of the appellant but relied on clauses 36.6 of the contract, which was not raised in the appellant's payment claim or the respondent payment response. The decision awarded the appellant 806,673 ringgit and 78 cents plus interest and costs. Judicial challenges. At the High Court, the adjudicator's decision was upheld, but the Court of Appeal overturned it, ruling that the adjudicator had exceeded their jurisdiction by relying on Clause 36.6 without the party's submission or consent. Federal Court proceedings. The appellant argued against applying strict pleading rules in SIPA proceedings, emphasizing SIPA formal and interim nature. The Federal Court dismissed the appeals holdings. First, the adjudicator jurisdiction is strictly limited to matters referred under Section 5 and 6 of SIPA. Second, the reliance on Clause 36.6 constitute a jurisdictional overreach. Third, the adjudicator's failure to invite submissions on Clause 36.6 amounted to the denial of natural justice. Conclusion. The adjudication process, particularly under frameworks like the Construction Industry Payment and Adjudication Act 2012 (SIPA), is intended to provide a swift interim resolution payment dispute in the construction industry. Its key characteristics include simplicity, informality, and a focus on resolving dispute based on documentation and submission provided by the parties. However, as illustrated in the case of Anas Construction versus JKP, adjudicators are bound by strict jurisdictional limits. They can only consider matters specifically raised in the payment claim and payment response, as outlined in the relevant statutory provisions. Departures from these, such as relying on contractual clauses not referenced by the party, the risk exceeding jurisdiction and violating principle of natural justice.